Just a few days ago, the 9 justices of the Supreme Court handed down a decision. But this wasn't just another ruling. This one has set the stage for a fight that will decide who gets to be an American. At stake is a single sentence in the 14th Amendment to promise made after the Civil War that anyone born on U.S. soil is a citizen. For over 150 years, that promise has been the bedrock of American identity. Now, a presidential executive order is trying to end it. The court's latest decision didn't settle the issue. Instead, it lit a fuse on a 30-day countdown that could throw the country into chaos and redefine citizenship for everyone. To understand how we got to this point and what's truly at stake, we have to go back to the moment this definition of citizenship was forged, in the fire of the Civil War. Before the Civil War, the United States had a fatal flaw in its operating system. The Constitution, for all its revolutionary genius, was dangerously vague on a huge question: who actually belongs here? It recognized state citizenship, but the rules for who was a citizen of the United States were a mess unclear and constantly fought over. This ambiguity allowed states, especially in the South, to build a racial class system where rights were handed out based on skin color. Free Black Americans, even those whose families had been here for generations, lived in a kind of legal limbo. Many states considered them just inhabitants, not citizens. This simmering crisis boiled over in 1857 with one of the most infamous decisions in the Supreme Court's history: Dred Scott v. Sanford. Dred Scott was an enslaved man. His owner had taken him from the slave state of Missouri to live in Illinois and the Wisconsin Territory, where slavery was illegal. When he returned to Missouri, he sued for his freedom. His argument was simple and logical. Since he'd lived on free soil, he should be a free man. The case crawled its way to the Supreme Court, which didn't just rule against Scott. It tried to settle the citizenship question once and for all with catastrophic results. Chief Justice Roger B. Taney, writing for the 7-2 majority, declared that no person of African descent, enslaved or free, could ever be a U.S. citizen. His reasoning was a brutal and complete rewriting of American history. He wrote that black people were beings of an inferior order who had no rights which the white man was bound to respect. It was a legal and moral gut punch to the nation. The court said that Dred Scott, as a black man, didn't even have the right to sue in federal court because he wasn't a citizen. And then it went even further, declaring the Missouri Compromise unconstitutional and saying Congress had no power to ban slavery in the territories. It basically classified human beings as property under the Fifth Amendment. The Dred Scott decision wasn't just a legal opinion. It was a match on a powder keg. It wiped out decades of political compromises and told millions of people born in America that they would forever be outsiders. It shattered any hope for a peaceful end to the slavery debate and made war almost inevitable. It defined American in the most narrow, exclusionary way possibly, definition so broken that only a war could fix it. The Civil War answered the slavery question with blood and iron. But winning on the battlefield didn't automatically fix the broken logic of Dred Scott. The nation was back together, and millions of formerly enslaved people were free. But their legal status was a huge, unanswered question. Were they citizens or just freed subjects, still denied the basic rights that come with belonging to the nation? To solve this, and to make sure no future court could repeat the sins of the Taney Court, Congress launched a constitutional revolution. Their solution was the 14th Amendment, ratified in 1868, and its very first sentence was written to be a direct takedown of Dred Scott. It reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." Let's just break down how radical those 28 words really were. First, all persons. Not all white persons, not all people of European descent, but all persons. That was a deliberate choice to make citizenship universal. Second, born or naturalized in the United States. This created a clear, simple rule. It flipped the old system on its head. Before, your U.S. citizenship often depended on your state. Now, there was a national standard that states couldn't touch. If you're born here, you're one of us. Period. This principle, known as jus soli, or right of the soil, was chosen specifically to make the promise of citizenship broad and automatic. The undisputed goal was to grant immediate citizenship to freed slaves. But what about that little phrase, and subject to the jurisdiction thereof? This is the phrase at the heart of today's entire debate. Opponents of birthright citizenship claim it was meant to exclude the children of non-citizens. But the history shows something totally different. When the amendment's framers debated this clause, they were clear about what it meant. Subject to the jurisdiction was meant to create a few very specific exceptions. The children of foreign diplomats were subject to their home country's laws and members of an invading army. At the time, it also excluded members of Native American tribes, which were seen as separate nations. One senator who helped write it said it simply restated what was already the law of the land. The point wasn't to create some new hurdle to becoming a citizen. The point was to lock in a promise of equality, to ensure that politicians and judges could never again use race or ancestry to decide who gets to be an American. The 14th Amendment was a clear fix for the Dred Scott problem. But its powerful, all-encompassing language soon faced a new test. The question was no longer about the children of slaves, but about the children of foreigners, who had come to America for a new life. Did the guarantee apply to them, too? This question would be answered by a man from San Francisco named Wong Kim Ark. Wong Kim Ark was born in the U.S. in 1873. His parents were Chinese immigrants who, because of racist laws like the Chinese Exclusion Act of 1882, were not allowed to become American citizens themselves. They were permanent residents with a business in San Francisco, but legally, they were foreigners. In 1895, when he was 21, Wong took a trip to China. When he sailed back into San Francisco, he was stopped. The customs collector wouldn't let him back in, arguing that because his parents were subjects of the Emperor of China, he wasn't an American citizen, even though he was born on American soil. The government's argument came down to that key phrase, subject to the jurisdiction thereof. They claimed it meant owing complete political allegiance to the U.S., since Wong's parents owed allegiance to China. The government argued Wong himself wasn't fully subject to the jurisdiction of the U.S. at birth. It was an attempt to sneak the right of blood into a constitution built on the right of the soil. The case, United States v. Wong Kim Ark, went all the way to the Supreme Court. In 1898, the court made its landmark decision. In a 6-2 ruling, they sided with Wong Kim Ark. They did a deep dive into the history of the 14th Amendment and English common law and concluded the jurisdiction clause was clear. It just meant being subject to the laws of the United States, which Wong Kim Ark definitely was. The only exceptions were the kids of diplomats and invading armies. The court affirmed that a child born in the United States of parents of Chinese descent becomes, at the time of his birth, a citizen of the United States. It's hard to overstate how important this ruling was. Wong Kim Ark cemented birthright citizenship as the law of the land for everyone, no matter where their parents came from. It rejected the idea that the government could pick and choose citizens based on ancestry. For over 125 years, this decision has been the legal foundation that made America a nation of nations. Understanding this history is everything if you want to understand today's fight. The precedents set by the abolition of slavery and the case of a Chinese-American man from San Francisco are the very things on the line right now. If you're getting value from these deep dives into the legal battles that define our world, take a second to subscribe and hit that notification bell. It's the best way to support the channel and stay informed. Now, let's get back to how this 125-year-old precedent is on the verge of being broken. For over a century, Wong Kim Ark was considered settled law. The debate was over. So what changed? How did we get from a core constitutional principle to a national crisis? The shift didn't start in the courts, but in politics. A fringe legal theory, one that mainstream scholars had dismissed for years, started to pick up steam. This theory basically re-argued the exact same points the government lost in the Wong Kim Ark case. It claims, subject to the jurisdiction thereof, means the children of undocumented immigrants or even legal temporary residents don't count, because their parents owe allegiance to another country. This argument ignores a mountain of history and the clear text of the law, but in a polarized political climate, it found an audience. This long political campaign led to January 20, 2025, when President Trump signed Executive Order 14,160. The order aimed to do what was once unthinkable: end birthright citizenship with a pen. The order directs federal agencies to deny citizenship documents like passports and Social Security numbers to children born in the U.S. if their mother was here unlawfully or on a temporary visa. This was a direct assault on the 14th Amendment and more than a century of precedent. The backlash was instant. Civil rights groups, immigrant advocates, and 22 state attorneys general filed lawsuits, all arguing the president can't just rewrite the Constitution on his own. Judge after judge agreed, issuing universal injunctions that blocked the order from being enforced against anyone in the country. For a moment, it seemed like the system was holding the line, but the administration took the fight to the Supreme Court, not by arguing the order was constitutional, but by challenging the power of the judges who had blocked it. And that's what led us to the edge of the cliff. This brings us to the bombshell from last week's Supreme Court ruling in Casa v. Trump. In a move that has thrown the country into a state of legal chaos, the court did not rule on the main question. They didn't say whether a president can end birthright citizenship. They didn't touch the constitutionality of the order itself. Instead, the 6-3 majority ruled on a dry procedural issue: universal injunctions. The court said the lower court judges likely went too far by blocking the policy nationwide. According to the majority, a judge's power is generally limited to helping only the specific people involved in the lawsuit. But the court also recognized the chaos this would create. So it put its own decision on hold, ruling that the executive order cannot take effect anywhere for 30 days. This is the bombshell. The Supreme Court didn't settle the issue. It lit a 30-day fuse. Once that pause is over, the legal firewall that protected birthright citizenship across the country could crumble. It opens a terrifying door. The administration will no longer be blocked by a nationwide ban. This creates the very real possibility of patchwork citizenship. A child born in Texas to an undocumented mother might be denied a Social Security number. Meanwhile, a child born under the exact same circumstances in California might be granted full citizenship because their state is part of a lawsuit. Your status as an American could depend entirely on what state you're born in. It would create a permanent underclass of people born and raised here, but denied the rights of citizenship, unable to vote, work legally, or even get a driver's license. While legal challenges are furiously being filed, we are entering a period of incredible danger and uncertainty. The Supreme Court's decision has pushed the country to a fork in the road. What happens next will send us down one of two very different paths. The first path leads to a patchwork nation. In this future, the administration pushes its advantage the second that 30-day pause is up. It starts enforcing the executive order wherever it isn't explicitly blocked. This would trigger a legal and logistical nightmare. The country would be split, with citizenship rights changing from state to state. It would lead to years, maybe decades, of lawsuits as hundreds of thousands of people are forced to sue for a right that was once guaranteed at birth. The human cost would be immense, creating a generation of stateless children living in the shadows. The second path is a final constitutional showdown. The chaos from the injunction ruling could force the issue back to the Supreme Court. But this time, they wouldn't be able to dodge it. They would have to rule on the merits. Does the 14th Amendment's citizenship clause mean what we've all thought it meant for 150 years, or not? The court would have to look Wong Kim Ark square in the eye and decide if precedent still matters. They'd have to decide if the Constitution can be rewritten by one person in the executive branch. This isn't just about immigration policy. It's about the fundamental structure of American democracy. Critics argue that letting a president redefine a right that's written into the Constitution would be a dangerous shift in the separation of powers. The Supreme Court did not give us a final answer. Instead, it lit a fuse and started a clock. By striking down the injunctions that held the executive order back, the court has kicked off a chaotic scramble of new lawsuits and political maneuvering. The question of who is an American our question we thought was settled in the ashes of the Civil War and affirmed by the case of a Chinese American. Cook over a century ago is now dangerously open again. The promise of the 14th Amendment, that being born on this soil makes you one of us, is facing its greatest test since it was written. The next month may not bring a final resolution, but it will absolutely determine the battlefield on which the future of American citizenship will be fought. If you want to understand the other major cases the Supreme Court is deciding this week that could change America, check out our video on that here. And as always, subscribe for more breakdowns of the laws that shape our world. Thank you for watching.